So now, in terms of common law, a building forms part of the land. Everything built on the soil belongs to the soil as well. The principle, there's also another principle that says that the owner of the soil is also the owner of the sky above it. How then does this apply to a sectional title scheme? And how does a sectional title scheme work from a legal standpoint? Do I, as an apartment owner on the third floor, hold any right over the land below should something happen to that land below? So
I'm so excited that you're giving me that question. It's actually one of my favorites. This is one of the only things I enjoy about sectional title is the complexity of the law behind it, because this is super old law. This is very strong Roman law and Dutch law as well. Actually, fun fact, in Roman law, we actually saw this divided ownership, not shared ownership, not like two people own a property together and then we use the term undivided share of a property, because you can't break a property up, a full title property. You can't break him up and Chris, you and I buy a property together. I own this side of the property, you own that side of the property. You can't own a full title property like that. However, the Dutch guys came in and they actually came up with a slightly more defined way of doing it than the Romans. Because remember, when we talk about Roman law, we really talk about those Urmies with the living in the night sheets and eating grapes and stuff. I would have thought, you guys, to be honest, I think we would have been those people, those philosophers, jurists talking about, but what about this and what about this while we eat grapes in, sheets. I think I would have worn something slightly more comfortable, but be that way, it's that. So obviously, in the time we're talking, there weren't as many people on Earth as we currently have. And so in Roman law, it wasn't so important. But however, if you think back on Roman kind of structures, the buildings were built bigger and slightly shared ownership on one piece of land, and they started developing it. And then the Dutch came in, and remember, Holland is this big, and actually Holland is built more into the sea than out of what it was supposed to be. They like moving into the ocean there. So the Dutch had to really optimize their space, and this is why from Dutch law we see much more like gebreekte eiendomsreg. That was more my Afrikaans version on a very Dutch term, but I'm not going to give you my Dutch today. So basically what they said is, if we're building, we only have this much land, but we have this much on top of the land. Okay, how do we deal with this now to build up, but we don't have the common law position of when you own land, everything attached to it and everything on top of it belongs to you. I just want to say in inverted commas, in brackets here on this side now, remember, you do not own all the way up. You have a limited sky ownership. So you can't build, that's why you can't build like a 59-story building in the middle of a suburban area. You can't go up. You can't put poles and stuff up over a certain limit. Your title deed will actually give your sky limitation as well. So it's something quite important to know. But yes, you do own it, so you can plant a tree, you can build a tree house in the tree. That's cool, it is yours. But when it comes to sectional title, what the Dutch did is they said, okay, let's change the way it is. Let's change the common law position, and let's say we build properties on top of each other, but you have full ownership of your property. So let's not talk sectional title for a second. Let's talk ownership in a context where you have one building and multiple owners, but it's a multiple story building. Unfortunately, that would still be undivided shares in that property. The only way we can break ownership up is in a form of sectional title, and that is from the Sectional Titles Act, which only came into our law very recently. 1971 was the first time it was promulgated, only in 1973, which was like basically yesterday. And so it's still a very new part of our law. It's a pleasure for all the people that I just called very young right now, who's around 50, but it's a pleasure. So the reason why that's important is you still have full ownership of that property, but in sectional title, you have limited freedom. So you have, remember always when we talk about the right of ownership, we say you have this full collection of rights. In a sectional title context, some of the rights are slightly limited. For instance, you now have a body corporate, and a body corporate can decide we are painting the building orange. Personally, I love orange. That's, my firm's color, but I wouldn't want to live in an orange building. But if the majority of the body corporate votes for an orange building, now you live in an orange building. That is limited rights. If you want to paint yours a slightly more appropriate color, cool, but you can't do that because you've chosen to take advantage of this multiple ownership on one piece of land, but you gave away some of your rights for the benefit of having this shared and joint ownership. So as an owner of a sectional title unit, you only own the unit. Even the land would be either common property or exclusive use areas, but you don't own that in the full sense of property ownership. You have a limited right to it, and cool that you have the right, but you can't go wild and, for instance, decide that you want to, build up, but there's a neighbor on top of you. You can't just drill a hole in the wall and be like, but it's my property. It's also that person's property.
Thanks so much, Cilna, for that answer.